Thanks, Justine. So, hi everyone, and welcome to this seminar on possession and homelessness in a time of coronavirus. My name is Tessa Buchanan. I'm a barrister in the housing and community care teams at Garden Court. Thank you very much for attending this seminar held via Zoom, which is obviously very new and exciting, I think for us anyway, and for probably quite a lot of you. Having said that, we rather wish that we weren't holding it. We wish that we didn't have to be here talking about coronavirus and seeing you all on small screens as opposed to in person. But given that that's the case, we're pleased that you could attend. I want to say firstly that the thoughts of Liz, Justine and I, and of the housing team at Garden Court, and indeed of Garden Court in general, are with all of you and all of your loved ones at what is a really difficult and strange time for all of us. And we very much hope that you are all keeping safe and well. And we want to say thank you as well for carrying on, for doing the incredibly important work that you do, helping some of the most vulnerable in our society at this very difficult time. You guys are at the coalface and we are really grateful to you for that. And we want you to know that we're here, we're ready to help, and we would love to assist you in any way we can. First, a few housekeeping points. I'm not going to tell you, as I usually would, where the nearest fire exit is, because I don't know. And I'm not going to tell you that in the event of an emergency, we should all be gathering in Lincoln's Fields, because that would now be an illegal gathering under the new regulations. But what I am going to deal with is a few kind of technical matters. Firstly, this session is being recorded. Now, what that means, as far as we understand it, is that the shared screen, which is the slides that you see, plus the speaker's screen, so that would be me at the moment, and also the chat is all being recorded. We don't believe that your individual screens, unless you're speaking, are being recorded. However, it is a new technology, and we would say that if you are worried about it, it may be best just to stop your video and to listen in. Secondly, those slides that you can see will be sent out to you after the webinar is finished, so don't worry about writing everything down. They will be available to you. Can I just check that everyone can hear me, because I have had a message saying that somebody can't. Yeah, okay. Oh great, it's working now, I'm told. So we really welcome your questions and also your comments, your experiences as to how things are going in this new climate. But because there are quite a lot of you, we're not going to take oral contributions. We're going to ask instead that you put any questions or comments that you'd like to make in the chat function at the bottom of the screen. I will then pull them out, and hopefully there'll be time at the end for a few of your questions or comments to be ventilated and for the speakers to answer them. To that end, I have muted you all and would ask please that you remain muted throughout the seminar, because otherwise it's just a bit chaotic. So please remain muted, but do feel free to make enthusiastic use of the reactions buttons, so thumbs up and claps, or indeed the chat function as well. So if everybody could just make sure that they're muted. Then turning to our speakers, firstly, we have Justine, who'll be speaking about possession. Justine Compton is a member of the housing team here who has specialised in housing law as a solicitor and then as a barrister for more than 20 years. She is hugely experienced and she has particular expertise not only in possession matters, but also in dealing with vulnerable clients. She is regularly instructed by the official solicitor on behalf of people who lack capacity, and she has also recently been appointed as a deputy DJ. So we're really pleased that she could speak to us today about possession in the time of coronavirus. She will be followed by Liz Davies, who is a very well-known expert on homelessness. She is an author of the textbook Housing Allocation and Homelessness. And in fact, on that point, we're really pleased to be able to share with you that our publishers, Lexis Nexis, have agreed that a free PDF of that book can be made available to assist people who are working away from the offices at that time. So look out for details on that. We don't have the exact time at the moment, but we think it will be soon, and we hope that will be very helpful to all of you. Liz is rated as a star individual in Chambers and Partners and regularly appears in the Court of Appeal, including, I think, most recently in the case of Al Ahmad and Tower Hamlets, the case involving an extension of time in homelessness cases. And we're also very lucky to have her as a recently appointed head of Chambers. So we'll be kicking off firstly with Justine on possession in a time of coronavirus. Justine.
Thanks, Tessa. So I'm going to deal first of all with the legislation that's just come in as of the 25th of March. I'm going to be dealing with the slides, taking you through them. If there are any technical difficulties, please do put in the chat if there are any difficulties with you seeing the slides, and then hopefully we can try and resolve any problems that you have. So I'm just going to move down the slides, and as I say, I'll be moving through them and talking to them as I go. So the Coronavirus Act 2020 received royal assent on the 25th of March, and it's to deal with all of the a wide range of changes required in response to the coronavirus crisis. So not just in respect of possession claims, but the whole range. The Act is wide-ranging, and you will see from the fact that we're dealing with Section 81 of the Act and Schedule 29 that the Act is extensive. But as housing practitioners, what we need to be concerned with are the sections that I've put on the slide, Section 81, but the real detail is within Schedule 29, which I'll come to in a moment. The changes made by the Act, as far as we're concerned, focus on the notice periods given in the various notices within the statutory regime. So that's the Housing Act 85, 88, the Rent Act, and various other statutes relevant to possession claims. So the Act applies to notices received on or after the 26th of March 2020. That's an important date because when your clients are coming through the door, you need to be looking at the date upon which the notice was served. So currently the provisions are in place until the 30th of September 2020, although there is provision under Section 1 subsection 2 for this date to be extended. There is no provision for that date to be reduced, so there's pretty much a guarantee that the notice period for the various notices will not be less than the 3 months dictated within Schedule 29. So I'm just moving down the slides. Liz, I don't know whether you've done something to the slides, but they're not moving. So let me just see if I can do something about that. Okay. So apologies for the slight technical hit. Okay, so Schedule 29. Going through each of the individual parts, I'm not going to dwell on Rent Act tenancies. There's not many around anymore, but Section 2 applies if you need to look at the schedule in respect of any Rent Act tenancies. Section 3 amends the Section 83 notice, and that's to extend the notice period to a minimum of 3 months. As you go through the schedule, you will see that the mechanism for achieving the government aim, which is to protect renters and those in rented accommodation by extending the notice period. So the Housing Act 1985, Section 83 notice, the minimum period now to be given is 3 months. Now you'll be familiar with the dates that are normally specified under the various grounds in the Section 83 notice. they're based on the notice to quit period, which is 28 days. So quite a significant extension for those receiving Section 83 notices. Under Section 8 of the Housing Act 88, so looking at Section 6 of the schedule, you will recall that the notice period for grounds are different. Grounds 1, 2, 5 to 7, 9 and 16 all require 2 months notice. That is now extended to 3 months. The remaining grounds, and importantly ground 8, so the mandatory rent ground, grounds 12 and 14, used to be 2 weeks, that's now 3 months. So for those receiving notices on the grounds of antisocial behaviour, that's quite an extension that they're receiving in terms of the notice period. So right across the board, 3 months is required. And as I say, even under ground 2 of the Housing Act 85, which again is a nuisance ground, that again is a 3-month period. What's important to note, though, in terms of ground 8 under the 88 Act is that there's been no change to the threshold for meeting the ground 8 requirements. And that's going to be difficult in these very difficult times of financial hardship, both for those receiving 80% of their wages, or for some that have fallen through the cracks and receive nothing, or for the 950,000 new people claiming universal credit. It's not going to be too difficult for 2 months of arrears to creep up. And I think the government have really missed an opportunity to increase the threshold for ground 8 cases. So whilst it's generally helpful to receive the additional 3 months, it's not really going to make a great deal of difference for those in financial hardship and facing rent arrears, particularly with an assured tenancy. So query whether this is a window of opportunity for landlords to seize upon the fact that the ground 8 threshold has been met very easily. So just moving down through the slides, Section 8 deals with introductory tenancies. So you'll recall that the notice period normally is 28 days. Again, that's now 3 months. So quite a significant difference for those in receipt of introductory tenancy notices. The sections 10 to 12, that's where the modifications to the forms come in, and you will see from the changes being made to the various notices that it's very clear that they have been modified. Now, I'm sure you'll be aware that the Section 83 notice is found in Part 1 of the Schedule to the Secure Tenancies Notices Regulations 1987. So the Section 83 notice, it appears on the government website, now states specifically as modified by the Coronavirus Act 2020 in the title. So it's clearly important that you check that the correct notices are being given and the latest notices are being used in the correct format. There's a new Form 3, so that's the Section 8 notice. Again, it refers to being modified by the Coronavirus Act. And it states clearly that landlords should be using these forms up until the 30th of September 2020. The new Form 6A, that's the Section 21 notice. Again, it states very clearly that landlords should now be using these forms. So when your clients are coming in, you want to be checking that the correct format's being used. Now, I'm sure the social landlords will be on top of the new legislation, but query whether the private landlord will be aware of these changes and whether or not they will be using the correct notices and indeed putting on the correct notice period. Now, clearly the court can, if just and equitable, can dispense with notices. But of course, in doing so, they will bear in mind that this legislation was brought in for a reason and that the notice period extension was brought in to protect renters. So it remains to be seen how the courts will deal with any applications to dispense with defective notices. But I would hope that the court would take a fairly cautious view of allowing landlords to dispense with a defective notice that doesn't comply with this new legislation. So I'm just going to now move on to the practice direction, which really is essential in completing, if you like, this protection for those in rented accommodation. And it goes further than simply just extending notice periods, which only protect those within the statutory framework. So the Practice Direction 51Z is effective from the 27th of March 2020 and it ends on the 30th of October 2020 at the moment. And it really complements the provisions by putting a moratorium on all evictions and delays possession claims. So any claim which falls under Part 55 in terms of it could be trespasses, it could be the usual statutory claim for possession, it could be those with no security at all. They are all stayed under PD 51Z. Enforcement proceedings of any existing possession orders, importantly, are also stayed. And that moratorium is until the 25th of June 2020, but query whether it will be extended in due course. So in terms of clients who have eviction notices, they're not going to be evicted. The bailiffs are not going to be going out. They're not going to be carrying out evictions where, even if a possession order has expired or there's been a breach of the possession order. In the last seminar that we did on Friday, a question arose as to whether or not a formal application should be made because the courts are prioritising staying any enforcement proceedings. And the conclusion that the panel and others came to was that an application really should be made as a belt and braces approach, because whilst there is an automatic stay, clearly what you don't want to happen is for nothing to be done and for the court not to be staying the possession proceedings. And then obviously a bailiff's warrant is issued as soon as we come through this crisis. So the application, if it's made, will have to be dealt with, and ultimately a decision will need to be made, a judicial decision will need to be made on any application. So if the application is stayed, it can still be dealt with once the crisis period is over. Just also note that PD 51Z doesn't apply to injunctive claims, so injunctive relief is not included in the practice direction and no stay applies. That's good news for those seeking an injunction if they're being illegally evicted, and in terms of those needing urgent repairs. But clearly the same goes for those with antisocial behaviour claims for injunctive relief against them. And so they're cases that you may still need to be dealing with. Okay. All right, so I'm going to now move on to the guidance that has been issued. Now, this is for landlords and tenants. It was issued on the 28th of March. But it's non-statutory guidance, so it's not binding, and it really has no teeth to it. So it says a lot of good things that I'm sure those representing tenants will wholeheartedly agree with. But whether or not that this actually amounts to any sort of protection for our clients remains to be seen. The government is doing a lot of urging of landlords. It's urging landlords to not issue notices, to not issue claims, to reach agreements with their tenants. But there really isn't anything in the guidance that says if landlords completely ignore this guidance and still issue notices against their tenants, there will be no consequence. So unlike the protocol that landlords are required to follow, social landlords, there are consequences in terms of costs and in terms of possession orders being made. The guidance doesn't contain any of that. So whilst it has the right sentiment, really one questions whether or not landlords who at the end of the day are renting out their properties for commercial gain, they're not doing it for altruistic reasons. What's the motivation for them to essentially let their tenants off the hook and give them time to pay? We're going to look later on at what the guidance says about the obligations of landlords, and of course the obligations to pay rent and to carry out repairs remain, and the guidance is clear about that. So really, in terms of contractual obligations, this guidance doesn't do anything to change that. It simply encourages a spirit of cooperation. But as I say, whether or not private landlords will be interested in that, particularly if they can't pay their mortgage, if there are rent arrears, we'll have to wait and see whether this guidance amounts to anything at all. So, so the request for landlords to not issue notices, claims or continue eviction proceedings, the PD 51Z really helps with that because it really puts a stay on everything. So whether or not landlords take any notice of the guidance, at least the protection is there that nothing is going to happen for a period of 3 months. But notices can still be issued. So if you're a tenant who you're doing your best, your income has fallen, you've got the kids at home, you're not able to work, you've got all of this stress of the whole crisis period going on, but yet you still receive a notice saying you're going to have to look for somewhere else to live because you're in rent arrears. Why the government didn't stop notices from being issued for the 3-month period, again, it seems to me to be an opportunity missed to relieve tenants of that pressure and of that worry of needing to find somewhere else to live, which in the current climate is virtually impossible. So it's disappointing that the government hasn't really gone further to protect tenants as it said it wanted to. So moving on to the other bit of the guidance dealing with the pre-action protocol, which, as I've mentioned, I think that would be of some benefit further down the line when courts are considering whether to make a possession order and the cost implications. If the protocol is to be extended, which the government says it will be, then I think that will have more teeth and more consequence. But at the moment, it's not yet in place, and there's no indication in the guidance as to whether and when that's going to happen. So just a quick mention about licensees. So licensees, lodgers and those with no security of tenure, the guidance makes clear that they are not protected by the Coronavirus Act. So that's Schedule 29. So the notice period for a notice to quit remains the same. They don't get any longer. Clearly, PD 51Z gives them some protection because even if that notice is issued, any new claims are not going to be processed and landlords won't get a possession order even after the 28-day notice period has expired. The guidance also warns landlords that once the stay is lifted in 90 or possibly more days, that will inevitably result on a huge pressure on the courts of new possession claims coming through and existing possession claims needed to be processed. So the guidance does warn landlords that the process that would normally take perhaps 6 to 8 weeks will take a lot longer. So at least that will give tenants some additional time if they do need to get their universal credit processed, if they need to make payments, if they need to find alternative employment, for example. So the final thing to say on the guidance is there's a chapter on the repairs part, because clearly with the social distancing provisions, there's certainly an issue as to what extent can tenants get their repairs done. Now, the guidance makes it absolutely clear that the obligation to repair remains, and that landlords should still be regularly reviewing and maintaining their properties. The guidance says it's no reason, the current crisis is no reason to allow dangerous conditions to persist. Conversely, tenants should allow landlords access to inspect or remedy urgent health and safety issues. Now, clearly, if tenants are in the very vulnerable group and at the high risk and the need of shielding, you would not expect a tenant to allow access. However, that clearly needs to be balanced with, if there's an urgent health and safety issue, then a tenant may have to allow access, but perhaps stay isolated as much as possible. It's really a balance, and all of this, I think we've all come to realise it's a balance of looking after your own health and safety, but also making sure that the property in which you live in is also safe. The guidance gives specific examples, but it's not limited to these examples, of urgent health and safety issues which a landlord would be expected to repair and which a tenant should allow access for. That would be a roof leak, no heating or hot water, no washing or toilet facilities, broken disability equipment, or a security related problem like a broken window or door. Interestingly included in that is broken white goods. Clearly, with us all staying at home, there is a need to ensure that we can keep food fresh, and also to be able to keep hygiene up with washing clothes and bedding, etc. So that's listed as one of the factors which should be taken into account when deciding whether or not a landlord should be coming in and remedying any defects. Just finally, in terms of moving home, decanting and transfers, the guidance says these should all be delayed unless it's absolutely essential. So again, it's a balancing act. If you have some very significant disrepair in your client's home, and the idea was for them to decant to an alternative property, they need to weigh up the risk to them of moving to an alternative property and all of the risk that goes with that, compared to remaining in a property which is far from ideal, but perhaps is a better option than moving at the current time. So just moving on to some practical matters. You may know more about the current situation in the courts, receiving court orders, than I do. Certainly the position initially in London was that there was going to be no future block listing of possession cases. They were going to be unpicked and given separate hearing times. So that I think initially the idea was that people wouldn't all congregate in the same waiting room. Now the fallback position is that all of the possession cases will be dealt with remotely, and I'm sure that you will have been receiving court orders giving you hearing dates to be dealt with remotely. Again, that seemed to be the case in Birmingham, where the possession lists were dispensed with, and certainly the duty possession scheme is no more for the time being. I'm sure you will have all read the situation that Simon Mullins, one of our solicitors, reported, where he was in a tiny room, I think at Clerkenwell and Shoreditch County Court, with a client displaying symptoms. He had to then go in and represent that client, following which the rooms in which the client was and the courtroom were all sealed off, much to the amusement of those remaining in the waiting room. So clearly that's precisely the situation that the court process is meant to avoid, and hopefully you will all be receiving dates now to have remote hearings. There are some priority courts, however, that have been designated whereby they are open for essential face-to-face hearings. I understand in London, Romford and Central London County Court are the two priority courts. Possibly Croydon as well was also on the list. There are some courts that are suspended, which means they're temporarily closed, so no hearings will be taking place there, remotely or otherwise. And then there are some staffed courts, which I understand Clerkenwell and Shoreditch is one, that are open to judges and staff to work, but they're not open to the public. Now, it's unclear whether or not cases will be transferred to the priority courts that actually require a face-to-face hearing, but I assume that it will be the parties that will need to put that forward to the court, and the court will have to make a decision as to whether it satisfies the priority criteria. And please do put on the chat if you have any experience of the court orders that you're seeing, and how you're taking those hearings forward. So I'm now just going to finish off with a few headline points. So clearly notices already served in relation to possession claims. Nothing can be done with those. And of course you'll be aware of the 6-month expiry date on a Section 21 notice. So it may be that Section 21 notices that were near to expiry will have to be reissued. That's particularly expensive for landlords to have to go through that process, but actually it's stressful for the tenants, as I've already said, to receive further notices of eviction. Ground 8 threshold, as I've said, remains the same, unfortunately. So query whether or not landlords will take advantage of that. And really, it's only a delay. The government's protection really only amounts to a delay. And what Helper said in its statement to the government, this was on the 23rd of March, so before the Coronavirus Act was passed, but it says really the legislation amounts solely to an extension of 3 months of the notice period. This is not legislation to prevent an eviction process being started, but at its highest, it's a grace period of 1 month, and it's entirely inadequate to the crisis, to deal with the crisis at hand. And I think there's some merit in that statement, in that essentially after 3 months, all of this is going to be put through the courts at pace. As housing practitioners, we're going to be extremely busy dealing with the huge demand to put in either defences and really to progress these claims. And I suppose the advice would be use these 3 months to make whatever claims you can, to whatever funds you can, particularly in rent arrears cases. There's the Homelessness Prevention Fund, and there are additional funds that are being made available. So whilst we're not having to actively go to court and perhaps deal with the court side of things, hopefully our clients will still be in touch with us, and we can still help them to present the best case that they can when all of this goes back into court. I think I would cancel any autumn or Christmas holidays if I were you, because I think you're going to be hugely overworked once this all comes back into court. The other thing just to mention is it wouldn't be surprising to see a massive increase in illegal evictions. And the reason for saying that is that those impatient landlords that don't want to wait for 3 months, or indeed landlords who are perhaps in fear of their tenants. I mentioned on the slide about the Oxford doctor. There was a story that I read in the news about somebody working at the Oxford hospital on the front line, and his landlady, because they shared a joint kitchen and bathroom, was so fearful that he would bring the virus home that she evicted him illegally. and he was having to put his stuff in the car and travel back up to the north where he originally came from. But it wouldn't surprise me to see more actions like that by landlords who are not understanding the legislation, or simply just want their tenants out because they can't be bothered to wait. So illegal evictions and getting an injunction to prevent that is not stayed. So it may well be that you're going to have to be quite ready and waiting for those claims to be made, and for you to act very quickly to stop people being evicted during this horrific time for anybody to be facing eviction, never mind unlawful eviction. So I'll just leave you with the comment that Helper said, and really what they urged the government to do was to bring in enhanced powers against landlords who carry out or who attempt to carry out unlawful evictions, including further criminal sanctions. The government haven't acted on that, but I'm sure that in terms of making a claim for aggravated damages, the court will be very mindful to take into account the really terrible circumstances in which an unlawful eviction would give rise to a greater risk to those that have been evicted, and I hope that would play through to an increased level of damages awarded. I'm going to leave on that rather depressing note, but I hope that Liz can cheer you all back up with her presentation on homelessness and the good news that hopefully she'll be giving in regards to homeless clients. Thank you very much.
Great, thank you so much, Justine. That was really informative. Just a reminder, or for those of you who have joined late, firstly, the seminar is being recorded. Secondly, please make sure you're muted. And thirdly, we really do welcome all your comments and questions. Please put them in the chat function. You can send them to everyone, or you can send them to me privately, but please do get involved. We really want to know kind of what you're experiencing out there. And now, handing over to Liz on homelessness.
Yes, so thank you very much. Can you all hear me? I'm hoping you're nodding. Yes, I can see nods. Good. First of all, to echo what Tessa said, it's really nice to see you all out there, and you're beavering away for our incredibly vulnerable clients from the privacy of your living rooms or studies or bedrooms or whatever you happen to have. And it reminds me just how collective the housing law world is. And as Tessa said, here at Garden Court Chambers, we are here to help. You should call on the housing barristers, the community care barristers, for any help you need in any of your cases. That's the first thing. And then also to repeat what Tessa said, for those of you who've joined a little late, Tessa and Connor Johnson and myself are very pleased that our publishers, Lexis Nexis, have agreed that our book, Housing Allocation and Homelessness, will be available free in a PDF online. We hope very shortly. It was agreed a few days ago, and the publishers are still dealing with the technology. So we will tweet that and put that on the website. And we know that many of you use the physical editions and haven't been able to get hold of the physical edition while you're all confined at home. So we do hope that this will help. I'm going to run through where we are on homelessness. Justine said that this was more cheerful. I'm not sure that it is more cheerful, but anyway, there we go. And unlike what Justine has covered, this is entirely guidance, and it's not even statutory guidance. It seems to have the force only of goodwill. The government is relying on the kindness of strangers towards the homelessness. So one of the things I'm going to do is look at how this guidance fits in with the statutory duties in Part 7 of the Housing Act. Just going through what has happened in the last 3 weeks, the short history, it feels like 100 years ago, but a little under 3 weeks ago, on Tuesday, the 17th of March, the government announced £3.2 million available for emergency sleepers for rough sleep, emergency support for rough sleepers, and 2 days later, a general packet of 2.9 billion for local government and the NHS together. 1.6 billion of that was for local authorities, and the 3.2 million for rough sleepers falls within the 1.6 billion. I confess I am not a local government finance person. These figures make my head spin. I have no idea whether they are sufficient or not. So that was funding. And then the big announcement was 2.5 weeks ago, Thursday the 20th. Sorry, I'm jumping ahead on the slides. The second thing that happened was towards the end of that week was guidance for accommodation providers, that hotel and accommodation providers should remain open if they're part of the response to support key workers or vulnerable groups. And I've not put it on the slide, but the coronavirus regulations do provide for local authorities to request hotels to help with accommodation. So that's quite useful. And the government also provided guidance about self-isolation, staying safe and so forth for hostel and day centres providers of services for people experiencing rough sleeping. But the big bang was about 2.5 weeks ago, Thursday, the 26th of March, when the minister wrote to local authority leaders, and his letter, as I say, it's not statutory, it's not, certainly not legislation, it's not even statutory guidance, but it is guidance to local authorities. 4 basic principles. Local authorities should be focusing on people who are or are at risk of sleeping rough, and those who are in accommodation where it's difficult to self-isolate. Local authorities should be making sure that those people have access to facilities that enable them to adhere to public health guidance, ideally single-room facilities. An important thing, which I'm going to come back to, that powers and funding should be used to assist those who have no recourse to public funds and who require shelter and other forms of support due to the pandemic. And local authorities are also encouraged to take measures so that rough sleepers can mitigate their own risk of infection and transmission to others by ensuring that they're able to self-isolate. How are local authorities to do that? They should be setting up a local coordination cell between themselves and NHS partners, seeking to stop homeless people from congregating in facilities such as day centre and street encampment, which sounds very Big Brother-ish, but then the carrot, urgently procure accommodation for people on the streets with support from the ministry. People were to be triaged into 3 cohorts: those who have symptoms, those who don't have symptoms but are obviously more vulnerable to the infection because they have pre-existing conditions, and others. And the programme should include getting social care basics such as food and healthcare to people who need it in self-contained accommodation, and it recognises the specific needs of those who have significant drug and alcohol abuse. In the long term, says the government, it will be necessary to identify step-down arrangements for the future. I had some difficulty in understanding that. I think it means we'll tell you when we need you to stop. But they said that it was imperative that rough sleepers and other vulnerable homeless people should be supported into appropriate accommodation by the end of that week, which was Sunday, the 29th of March, just 8 days ago now. And they repeated the funding announcement. So how does that fit with what we know are local authorities' statutory obligations under Part 7 of the Housing Act? Well, all of those people that we've just looked at are people who are homeless. And so once they are identified by local authorities or they approach local authorities, then in any event, the relief duty to help them to secure their own accommodation would be owed. The real issue, the big bang that this guidance provided, is the interim accommodation duty, which too many of our single clients normally do not end up being accommodated under. Local authorities will say that they don't have reason to believe that somebody who doesn't have children may have a priority need. But this, of course, the only way of interpreting it is essentially that the letter, the guidance, is encouraging local authorities to decide that those people who are sleeping rough may have a priority need, and usually that would be that they may be vulnerable. It leaves open the question as to what should happen when the relief duty comes to an end after 56 days. assuming that no longer term accommodation has been found for that person, given the demands of the pandemic and the fact that we're not allowed to move around. And as Justine just said, moving is only permitted under the regulations if absolutely necessary. Well, there's a whole big question then about whether accommodation duties would continue towards the end of the 56 days. But bear in mind that the 56 days in the relief duty is not an absolute cut-off point. The relief duty is to take reasonable steps to help secure accommodation for a minimum period of 56 days, and that period can be extended. Alternatively, of course, if somebody does have a priority need, then they will be entitled to some sort of accommodation duty at the end of the relief duty. It's a case of crossing the bridge when it comes to it, I think. We can remind ourselves what the legal test of vulnerability is. It's found most recently in the case from 2.5 years ago, Paniotu in the Court of Appeal. The relevant effect is an impairment of a person's ability to find accommodation, or if that person cannot find it, to deal with the lack of accommodation. The question to be asked is whether, when compared to an ordinary person, if made homeless, the applicant, in consequence of one of the characteristics, would suffer or be at risk of suffering harm or detriment, which the ordinary person would not suffer, or be at risk of suffering such that the harm or detriment would make a noticeable difference to his ability to deal with the consequences of homelessness. Of course, what is being said is that all rough sleepers are now at risk of more harm in a significant way. So how will you, if you are having an argument about interim accommodation, how will you argue that somebody is at risk of more harm in a significant way? Well, obviously, if you're sleeping rough, you're more likely to be exposed to contamination from others. If you have clients who have a pre-existing condition that wouldn't normally in itself be sufficient to make somebody vulnerable, then clearly exposure to the risk of contamination means that any symptoms that they might develop are likely to be more severe. And it goes without saying that if you are sleeping rough, then the ability to care for yourself if you do become ill would be extraordinarily difficult. The risk of exposing others doesn't really fall within the test of vulnerability, but again, it would be something that you would put in if you had somebody who might be a possible carrier of infection, as well as, of course, the risk to themselves. So it's a strange new world for us as homelessness lawyers. There may well not be arguments about vulnerability. What other sort of arguments might arise that would end up with local authorities saying that they're not under a duty to provide interim or emergency accommodation? They may decide that somebody is not homeless. For example, someone might have accommodation available for their occupation, but be saying that it's not reasonable for them to continue to occupy, either for the usual reasons, risk of violence, physical conditions, or for some reason that's related to the public health emergency, that they need to self-isolate because they're in vulnerable groups or they've been exposed to the possibility of the virus and the accommodation isn't sufficient for self-isolation, either to protect themselves or to protect other members of the household. Is the accommodation that they have, that's on homelessness, if accommodation is secured by a local authority, is it suitable given the need to self-isolate, given the guidance about avoiding sharing kitchens, bathrooms and toilets? And then we come to the big question for lawyers is, where do these duties come? Are they, as I suggest, duties that are enforceable under Part 7 of the Housing Act, in which case we know where the remedies and the avenues for challenge lie? Is it perhaps just the exercise of a power by a local authority? The general power would be under Section 1 of the Localism Act, which I'm going to look at in a moment. And if it's the case, then the only challenge, if a local authority is not accommodating, would be by judicial review. My suggestion to you is that if you are having an argument about whether or not accommodation should be provided, whether or not the accommodation provided is suitable, then you quote Part 7 of the Housing Act in your pre-action protocol letter. And if local authorities are going to say that it falls within some other jurisdiction, well, put the onus on them to say that and then review, and ultimately the administrative court will decide. What happens to those who have no recourse to public funds, given that we've just seen that the government is advising that they should also be accommodated? We know that they are not eligible for homelessness assistance under Section 185, and this letter cannot just suspend that statutory prohibition. They might have Care Act needs in the usual way. Bear in mind that the duty to meet eligible care and support needs and the duty to assess under the Care Act can now be suspended by local authorities under the Coronavirus Act, that's Schedule 12 of the Coronavirus Act. That's a whole separate seminar, and Garden Court is producing materials and training on that. Somebody who has no recourse to public funds who has children would fall within Section 17 of the Children Act. When I was writing these slides, I made sure, as I always do, to point out that those duties are subject to the prohibition at Schedule 3 of the Nationality, Immigration and Asylum Act. But of course, that's all about providing accommodation and services for a short period while the applicant is assisted to travel to their country of origin. And that's not a goer at the moment. Nobody is going to be travelling. So you need to note that, but it's not going to be a realistic problem, I imagine. We'll see. So that brings us, if someone doesn't have Care Act needs, doesn't have children, and can't fall within Part 7 of the Housing Act because they have no recourse to public funds and they're not eligible, and I'm talking about eligibility in very broad terms, obviously, then where is the power to help them? And it can only be at Section 1 of the Localism Act, the general power of competence. A local authority has power to do anything that individuals generally may do. We would all accommodate people given the chance. That is reliance on the kindness of strangers. There are prohibitions within the Localism Act. You need to look at Section 2 and Section 3. And there is existing authority that the Localism Act cannot be used where someone is not eligible for assistance. Our AR and Hammersmith and Fulham from about 18 months ago. That is very much ripe for challenge on human rights grounds, is my view. Again, I just touched the surface here. If you've got cases that affect people with no recourse to public funds who are not being accommodated, we're all happy to look at them. Moving on from the statutory duties and just giving you a little more about the guidance, the government has issued guidance on self-isolation for what the government calls vulnerable individuals, by which they mean they're using the term in the colloquial sense rather than the technical sense that we homelessness lawyers use it. And vulnerable individuals broadly are either people aged 70 or over, or less than 70 but with underlying health conditions, including people who are pregnant, and they are advised, if a vulnerable person in the household develops symptoms, the advice is to move him or her out of the home to stay with friends or family, which again seems unlikely currently. If that's not possible, that other members from the household must stay away from the vulnerable person as much as possible. So that may well promote applications for homelessness assistance, even where the vulnerable person has accommodation that is available to them. Is it reasonable for them to continue to occupy? And then we have the government's identification of extremely vulnerable people who are at very high risk of severe illness. Those people are supposedly being identified and written to by the NHS, because when you look at the list, clearly they are people who are already within the NHS system, and it's a very distressing and devastating list, really. People who are receiving treatment for cancer have their immune systems suppressed and so forth. And they are advised to be shielded or to shield themselves, which is the word Justine used. In other words, they're strongly advised to stay at home at all times, to avoid face-to-face contact with anyone for at least 12 weeks. And if an extremely vulnerable person is living in the household, the guidance is to minimize time spent in shared spaces, to try and keep 2 meters away, try to use a separate bathroom, because so many of our clients have separate bathrooms and toilets. But anyway, if there is only one toilet and bathroom in the household, then clean the toilet and bathroom after it's used by the extremely vulnerable person, and try to avoid using the kitchen together, eat separately, wash and dry utensils separately, and so forth. And I finish on this. This is the Health Protection Coronavirus Restrictions England Regulations 2020, which came out about 10 days ago. Those are the regulations that prohibit us all from going out, except for the purposes of food shopping, exercise and so forth. They are also, you will remember earlier on I mentioned that regulations allowed local authorities to request hotels to help provide accommodation. That's at Regulation 5 of these regulations, if you want to look it up. But Regulation 6 provides, during the emergency period, no person may leave the place where they're living without reasonable excuse. It's why we're all sitting here talking to each other on Zoom. But if you are homeless and you've not been picked up under the guidance, then the only redeeming feature is that you are not committing a criminal offence if you continue to remain homeless. In terms of the people who have been housed under this guidance, then there was an article in The Guardian last Monday, a week ago, which said that 4,200 rough sleepers had been housed within those 4 days between publication of the guidance and the end of the week. And that's not bad. General figures for people sleeping rough on any one night in England are around 4,700. They're thought to be a considerable underestimate, so far more than 4,700, but even so, 4,200, not a bad start. And Crisis, the homelessness charity, said it shows what you can do with money, an organisation and an assertive approach from government. And I suppose what I would say is that one thing that might come out of this pandemic is that maybe, just maybe, money, an organisation and an assertive approach from government continues past the public health emergency. And we do actually discover that we can reach a society where people are not generally sleeping rough and sleeping on park benches, and that actually government and local authorities are now committed to housing the homelessness. And that would be a bit of a silver lining. Tessa, I'm very happy to answer any questions. I haven't been following the chat, so you're just going to have to pick out anything that you think looks interesting. Thank you.
Sure, thank you very much, Liz. Before I move on to questions, Justine, I know you had a couple of things that you wanted to add. Do you want to do that? You just need to unmute yourself. Yeah.
Yeah, thanks, Tessa. Just a couple of things that I wanted to come back on in respect of the stay, which the practice direction currently provides for. Something that I have had to deal with in the last week, and I know one of my instructing solicitors, who I think is with us today, is where you have a consent order. So you've reached a settlement in perhaps a disrepair claim, and of course everything is stayed. So how do you get that settlement put before the court and approved? Because according to the practice direction, nothing can happen. And what we worked out between us, that to add into the preamble that the practice direction is to be lifted for the purposes of the court considering and approving the proposed consent order. And I think that's definitely worth pursuing, because it's in everyone's interest, particularly your client's interest, to get the money in the bank if there's a settlement figure to be paid, or in the rent account, and also if there are repairs which fall under the urgent category, that the landlord can get on and do those repairs without waiting for the 3 months to expire. So I hope that's helpful in terms of dealing with any compromising of cases that you're doing at the moment. The second thing just to mention is, if you have cases which fall outside the practice direction, so in other words, it might be an antisocial behaviour injunction case, and there are still things that need to be done, practice direction 51ZA allows the parties to agree an extension of time. That's not new, because 28 days has always been allowed for parties to extend the directions. But what the new practice direction does is to give you, the parties, 56 days to work out an extension of time. So obviously that's particularly helpful to know when you're seeking to perhaps put things off for a period of time, either for practical reasons or because other things need to take place, such as surveyors' reports or other things that need to be done practically before you can comply with the court direction. The PD 51ZA makes provision for an extension of time in relation to CPR time limits, practice direction compliance, and compliance with court directions. So all of that should help. Right, thanks very much, Tessa.
Great, thank you very much. I'm aware we are now at 12 o'clock. We have had a few questions in, which it would be good to deal with if possible. If you need to leave, obviously we do understand that. But just to deal quickly with what we've had. Firstly, question from Nathaniel about disrepair cases. So it appears to be the case that where works are not urgent, then it would probably be reasonable for them to be delayed until after the crisis. Certainly that, I think I would agree, that seems to be the implication of the guidance. So the two questions arising from that are, firstly, is the landlord liable in damages for this period for the delay? And secondly, if the landlord had reasonable notice before the lockdown but didn't complete the works before, what would be the position for damages in respect of this period of the lockdown?
Well, I'm happy to answer that. I think in both cases, clearly the damages would continue to accrue because the property is not in a fit state. It should not have been in that state in the first place. And by the time you're getting to issuing proceedings, one assumes there would have been plenty of time for the landlord to have carried out those works. It's clearly not the tenant's fault that there's the crisis, nor is it the landlord. But as we know, with any court proceedings where there is a delay, whether that be that the trial has been delayed because of lack of judicial capacity, that is not there to benefit the landlord. It's not there to penalise the landlord either, but it's nobody's fault. It's the fact of the matter is the proceedings cannot be concluded by a certain date, just as the repairs are not going to be able to be done. But I don't think if the tenant is sitting in a property that's in disrepair, the landlord should be let off the damages claim. So I think the whole period of time should be claimed for. Whether or not landlords, those who represent landlords, would come back with any response to that to try and minimise the damages, I'm sure they will try. But I think your starting point is you should claim for any period that the property is in disrepair, save perhaps if tenants are unable to give access. That might be a reason for damages not to be fully paid for that period. But I can't think of any other reason that would get the landlord off the hook, as it were.
Thank you. We had another question about the ground 8 threshold and what was referred to as the loophole in relation to that. That was from Mary. I think that is a reference to the tension between the fact that although the notice period has been extended, the underlying threshold at which point landlords can rely on ground 8, i.e. 2 months or 8 weeks of rent arrears, has not been altered, which obviously we see as a problem. Mary, that wasn't your question, then please do come back to me in the chat and I'll see if we can clarify it further. Another question.
Just to clarify that, I mean, there isn't a loophole. The point I was making was that the threshold hasn't been changed, and it's likely to be more easily met given the financial circumstances that many of our clients will find themselves in, particularly if, for example, they have claimed universal credit for housing costs, and with 950,000 other people, there's likely to be quite a significant delay. But because there's no moratorium on issuing notices, the ground 8 threshold of 2 months in arrears is going to be fairly easily met, in my view.
Thanks. I think this is a question for you, Liz. So individuals who are NRPF, so no recourse to public funds, those individuals who are housed but not eligible for housing benefit, are they at risk of a significant debt, or will the local authorities, do we think, be funding the accommodation out of the 1.6 bill figure that you referred to?
We don't know is the answer. The one, if you are accommodated, then you must be being accommodated under a license or a tenancy. And even if the license doesn't specify what would be normal charges, then the common law position is you're under a duty to pay use and occupation charges in any event, regardless of the terms of the license. So if a license is entirely silent about charges, then the starting point must be that somebody is liable contractually for charges. Having said that, if I don't know who asked the question. Sorry, the question said they're not going to receive any public funds for them, and they haven't got any income themselves. Then it's very hard to see how the local authority could collect that. If they're eligible, then there is authority that suitable accommodation provided under Part 7, that the charges that can be recovered from a homeless person put into suitable accommodation have to be reasonable. That's within the statute, and that reasonable depends on the individual. And the case of Yekini, Yekini, and Southwark, it's a judicial review from about 10 years ago, was somebody who was accommodated under homelessness and ceased being eligible for housing benefit. And the administrative court held that the reasonable charge should be as little as a peppercorn rent in her case, because there was a duty to secure suitable accommodation, and that duty did not come to an end as a result of her being unable to pay normal level charges for it. So under homelessness, there's certainly that authority. NRPF people who are not eligible are not being accommodated under homelessness, so you'd need to have the argument, but it seems to me that you've got the argument under the general power of competence under Section 1, and also under human rights obligations.
Thank you very much. And I also just want to make a point which Shushan Liu, our colleague, has very helpfully reminded me of in the chat, which is that there is currently an outstanding challenge to lift the NRPF conditions generally, brought by Dayton Pierce Glynn with the Unity Project. And as we understand it, the court has expedited the hearing of that, which is due to take place, I think, in the next couple of weeks. So that may lead to some sort of approval. We'll just have to wait and see. And I can see that Sue, as Luke's has very helpfully posted some guidance in the chat, so do have a look at that. I think the last question is from Nathaniel, and it's in relation again to the homelessness issues which have been discussed. So it may be difficult to distinguish between cases where people are being housed under Part 7 and under some other provision, because other features which would indicate a housing duty, such as personalised housing plans, are unlikely to happen. So I suppose that's the question really. Do we think that identifying features such as PHPs are likely to be missing, and therefore there may be a difficulty in identifying the provision? Liz, you're muted. Yeah.
And now I'm unmuted, aren't I? Yeah, Nathaniel, I feel like a politician because I want to say thank you very much for asking me that question. It's because I didn't touch on it within the relief duty. I mean, you could be aggressive. You could, once you've got your client in emergency accommodation, send a letter to the local authority saying it must fall within assuming that they're eligible, it must fall within Part 7. And therefore you must be accepting that this person is homeless, It follows that the relief duty applies. It also follows that the Section 189A duty to do an assessment of case and personal housing plan apply, and see what happens. You are right that local authorities who must be being overwhelmed, I haven't yet picked that up from local authorities, which is interesting, but they must be being overwhelmed, are likely to come back and say, well, either we disagree that it falls within Part 7, and if they do that, that would be very interesting, or we agree, but we haven't yet got to it. I would have thought in this climate, starting off a claim for judicial review for failure to do the assessment of case or the personal housing plan, which would be a breach of statutory duty, assuming that these people are housed under Part 7. So you've got your error of law, you've got your breach of statutory duty, but judicial review is a discretionary remedy. And I imagine that judges would not be wholly sympathetic unless there's a very good reason why you need the local authority to get on with producing those two documents. So I would start off by saying that if you want those documents, then certainly, first of all, ask for them, then send a pre-action protocol letter quoting Part 7, see what comes back, and then we'd have to review the merits of a JR, bearing in mind it's a discretionary remedy. But you don't ask, you don't get. Can't hurt to ask.
Great, thank you. So I think that's the last of our questions, and we are of course now over time anyway. So I'm going to draw things to a close now. Firstly, thank you so much to our speakers, Liz and Justine. I know you put an incredible amount of work in, which was done very quickly as well. And I hope people agree that it was all an incredibly useful briefing on where we are now in these strange new times. Secondly, thank you very much to all who contributed via questions and comments. We really appreciated hearing your thoughts and understanding the sort of issues that you're facing. Thank you again to everybody simply for being out there doing the hard work that you're doing in difficult times. It is needed now more than ever. This is not the first, but it's one of the first webinars that we've run, and we would be really interested and grateful for your feedback. Is there anything that didn't work, anything that you think we could have done better? Please do get in touch via the usual channels for that. We expect to be running more training as matters progress, both from the housing team, the community care team, I'm sure, and also other teams across chambers if you do other areas of work, so do look out for those. Like I said at the beginning, we're here to try and help you as best we can. So in addition to the formal training, do just get in touch with us if you have any queries, and we'll do our best to assist. Otherwise, thank you again for coming and enjoy the rest of your day. Thank you.